Hi, thanks for using my court coach. I'm Sarah, and I'll be your instructor today as we discuss how to prepare a findings and order after hearing. This form is also known as Form FL-340. If you've been tasked with the duty to prepare the findings and order after hearing that memorializes the orders that the court's made in the court, you generally need to serve this form filled out on the other party within 10 days of your court hearing date. The other party will then have 20 days within which to either sign it or to send back their objections. As usual with all our court forms, you want to fill out the identifying case caption information at the top. Below that, you're going to list the date, time, and department number or room number where the hearing took place. And when you are filling out time, keep in mind that you want to list the time that the hearing matter was scheduled for, meaning that if you had a hearing that was scheduled for 9 a.m. and the judge actually called your matter at 10 a.m., you would still list 9 a.m. here where it says time. Below that, you're going to list the judge's name. If there was a temporary judge, in other words, a substitute judge that doesn't normally appear in that department and is not regularly assigned to that department, then you would mark the box that says temporary judge. Below that, you want to list the date that the request for order that this order pertains to was filed and the name of the party who filed that request for order. Below that, you want to mark the boxes identifying the parties present. If either party had an attorney present for them, then you would also mark that box and list the attorney's name. Finally, below that, you want to identify what kinds of orders the court made that day and pertaining to what issues. So for instance, if the court made custody and visitation issues, you would mark the box that says as attached on Form FL-341 or other. There are certain forms that pertain to specific topics and issues. FL-341 is a form that further details the types of orders that courts can make in custody matters. You can opt to choose that if the court made custody visitation orders, or you can opt to summarize and write out the orders on your own and attach it to the back of this form. You'll see that each of these categories, custody, visitation, child support, spousal support, property orders, and attorney fees, has a designated form that you could fill out as part of an extension of the orders. Again, with all of these, you have the option of handwriting out the orders yourself. It's just a little bit more work. And if you do that, then mark other. If the court did not make orders on a particular topic here, then mark not applicable. If the court made orders that extend beyond any of these descriptions listed in 2 through 6, then mark as attached and describe what those orders are in attachment that you attach to the back of this form. If the court sets another hearing date to come back and review any of the orders, sometimes, for instance, they will make a temporary support order pending further information being received, and they'll set another hearing date out to review that information to make further orders on. Then you would mark box number 9, list the date, time, and department of the future hearing date, and identify the issues that will be discussed at that hearing date. At the bottom of this form, you want to mark the box that represents the opposing party that will be reviewing and hopefully signing this findings and order after hearing. Leave the section that says judicial officer and date blank. Eventually, once the other side signs this findings and order after hearing, you will submit it for filing with the court, and the judge's signature will be the final step in giving you a formal order after hearing. I hope you found this helpful. Good luck.